So welcome everyone joining us today to our webinar, which is launching a new EIFL provision on secondary publication rights. My name is Teresa Hackett. I manage EIFL's program on copyright and libraries. So I'll be moderating today's 45-minute session that's being organized jointly with the EIFL Open Access Program. And as Iryna mentioned, the webinar has been recorded and the recording and the slides will be available afterwards. And my colleague Edwaldus is also on hand here to assist with any technical issues that you might have during the webinar. So before we start with the first presentation, I have three brief remarks on the context and the background for this work. So firstly, on the context, last year in June, so almost a year ago, EIFL published a guide on rights retention and secondary publication rights that, taken together, are powerful tools to boost the achievement of open access to research. So the guide aimed to raise awareness of rights retention and SPR in EIFL partner countries in Africa, Asia, and Europe. And it sets out the key issues, how researchers can benefit, and how libraries can support their researchers in the process. So to raise awareness of legislative developments with regard to SPR and to provide policymakers with some sample language on what a good copyright provision might look like, we decided to introduce SPR into EIFL's draft law on copyright. So the EIFL draft law, including model limitations and exceptions for libraries and their users, is widely consulted by librarians and policymakers in EIFL partner countries when copyright laws are being updated. So we wanted to have a provision in there that also included secondary publication right. Then second, SPR, as you will learn or as you will see, can be found in a range of laws. For example, law on science, law on economics, as well as copyright. And there's really no right or wrong way to implement SPR. It all depends on the national situation. And in Ireland, in my country, for example, advocates are proposing to implement SPR in a research outputs and open access bill. So by drafting a copyright provision, we're not saying that SPR should be implemented through copyright. Rather, if a country chooses the copyright route, the EIFL language is a good starting point. And then thirdly, the provisions in the EIFL draft law since the first edition over a decade ago are designed to be realistic and achievable. So they align with international developments, and we check the permitted activities against copyright laws in Europe and the US, for example. And the reason we do that is to help support developing and transition economy countries against any pushback they might have from high-income countries when they're updating their copyright laws as a result of trade negotiations or negotiations or EU negotiations for partnership agreements, or indeed for EU accession to join the European Union. So the argument being that if your copyright law allows, I don't know, online teaching, for example, then why should we not be able to do it? So it supports the countries when they're in negotiating. So for SPR, which is of course not an exception, it's a right. We've picked the best elements from the 6 countries in Europe that have SPR to create a single provision that we hope is coherent, effective, and achievable. Now, it's also a work in progress, and I'm quite sure it'll be adapted over time as the thinking changes and as the environment changes. But I would like to express my thanks to the expert group that did the hard work in drafting this provision. That's Jonathan Band, who was the lead drafter, Faith Majikolagbe, the assistant professor at the Faculty of Law in the University of Alberta in Canada, Iryna Kuchma, EIFL OA program manager, and Milica Sheshkovic, the EIFL OA program project coordinator. I'd also like to thank the organizations that provided helpful comments to the working group during the drafting process. That's Knowledge Rights 21, LIBER, Open Data and Intellectual Property Institute, and Spark Europe. So with that, I will welcome and introduce two members of the expert group. Iryna Kuchma will briefly explain secondary publication rights and why they're important. Jonathan Band will present the main features of the SPR provision. And unfortunately, Faith can't join us today, so I'll provide then a short commentary on the key issues that were discussed by the working group. And after that, as Iryna mentioned, we'll have a few minutes for questions. And please pop your questions into the Q&A function and we will keep check. So Iryna, I'm handing over to you to briefly introduce SPR. Thank you.
Thanks a lot, Teresa. As Teresa already mentioned, when we say secondary publication right, or SPR for short, we refer to a legal right of authors to make their works openly available in parallel or after publication in a scholarly journal. So usually we refer to peer-reviewed versions of articles, for example, accepted manuscript, also accepted manuscript, or final typesetted version, publisher PDF. It's a legislative measure that makes it easier for researchers to comply with open access policies and also to provide open access to their works, even if there are no requirements from their funders, for example. What it does, as it enables preferably immediate open access, it really increases the impact of research because it enhances dissemination of research outputs which are made available in open access repositories. It helps to provide open access even if there is no formal agreement between the author and a publisher to enable open access to the research work, and it really supports open access and open science policies in countries. SPR provisions exist in different type of laws. In some countries, it's included in the copyright law, and then also laws on culture, economics, and it's a fundamental element of European research area policy agenda. In the previous work plan for 22-24, there was a proposition to have an EU legislation framework for copyright in the form of secondary publication right. And then this direction has been endorsed in the new program for 27, released on Friday. And in European Union Council conclusions, introduction of secondary publication right in European Union member state was welcomed as a good direction. And Teresa already mentioned that we have an EIFL guide available as a downloadable resource and also as an online page. With that, I'll hand over to Jonathan to introduce EIFL model law provision, and please, if you have any questions to Jonathan, use a Q&A. Thank you. Over to you, Jonathan.
Thank you very much. So just before we get started, you might be wondering, well, why do we need secondary publication rights at all? Um, because typically, the author is the rights holder, and they could, do this all on their own. And I think it's all this is to some extent an expression of the ongoing, I guess I'd say, frustration of policymakers and people, mainly in the sciences, but in other academic areas, with the slow uptake of adoption of open access. That the open access technology, or even the framework. You have open access publishers, and you have the Creative Commons licenses, and you have, again, the internet technology. It's all been around for 20 plus years, and yet open access is going, the adoption of open access has been slow. And even notwithstanding the fact that it's all these studies show that it has enormous benefits for the advancement of science, as well as for the advancement of the careers of the authors. And nonetheless, it's still, the adoption is slow, and there are, a lot of people have looked at this, and there's all kinds of cultural features that are involved with the culture of academic institutions and the tenure and promotion process. And a lot of that is a major obstacle, as well as, sort of like efforts by large commercial publishers to sort of slow the process, hijack the process, depending on your point of view. And so uh, that's forced various policymakers to try to say, well, what else can we do to move things along, changing um, academic culture, and the tenure and promotion process is very problematic. It's hundreds of years old, and you have intellectual freedom and so forth, and it's very difficult to dictate policy changes to these academic institutions, even though in some places there's efforts to do that. So this is yet another effort to try to move the process along. And if we could go to the next slide, please. You'll see that the actual what we're doing here is relatively uh, uh, simple and straightforward, as was mentioned before. An SPR provision, it doesn't need to be in a copyright law. It can be in other places, and so uh, even though it's been adopted in copyright laws in Austria, Germany, and the Netherlands, it could be in the science and technology laws, as it is in France and Spain, or the economics law as in Belgium, or the cultural laws in Italy. So the point is, because it's not necessarily, or it doesn't have to be a copyright provision. It can sort of fit into various different codes. But in part because EIFL has a model copyright law, it made sense to draft this provision as a copyright provision to be included in the EIFL model law for copyright. Um, and then you sort of have to think, well, what is SPR? Is it an economic right or a moral right? And those of you familiar with copyright law know that typically with copyright you have economic rights. The rights holder is able to receive remuneration if for people who are who want to distribute their work or copy their work, and perform their work. So those are typically seen as economic rights. But then there's the whole idea of moral rights, which we really don't have as much in the United States, but they're certainly in Europe as else and elsewhere, which is the right of attribution and the right of to prevent defacement or changing the work without the author's permission, often referred to as a right of integrity. Um, and so the question is well, is it economic to some extent, but it's also moral. I mean, it's sort of like the author retaining the right to make it available in an open access format. And so because it's not quite fish nor fowl, we ultimately decided to put it in, it's neither, it doesn't fit into either place. So we sort of made it into a separate article. So next slide, please. The provision has 5 paragraphs, and we'll start by talking about the definition. So the next slide, please. And you might say, well, why are we starting with definitions? But that's typically the way lawyers think of things, that you first define the terms, and then so you understand what you're talking about, and then it sort of makes the statute fit together more neatly. So there's basically 3 terms that are critical here to understand. So the first term is a research work, and so that's what we're talking about here is research works. And a research work is a work based on research, obviously, directly or indirectly funded. So directly funded by government, by public funding. Directly would mean, you have a grant. Indirectly funded could be the salary. So let's say it's an institution that gets some subsidies, or that's a public institution. And so you have a scholar there who has on salary, doesn't have a specific grant, but there's an expectation that because they receive salary, that they will produce scholarship. So a research work that is the function of the fact that they're an academic or scholar who has a salary, that would fit under the definition here. So directly or indirectly funded in whole or in part. And so it doesn't need to be completely funded. So again, let's say you have a grant. So it's a person's at a private institution receives a grant, but the grant doesn't necessarily cover the entire costs. So maybe there's a public grant, a private grant, or again, his or her salary is covered by the institution, private institution, but public grant. So the point is, it doesn't need to be funded entirely publicly, even if it has a fraction of the funding is public. Then it falls within the definition of research work. And also the definition includes third-party content, let's say an image or a table or a photograph that is required for the purpose of understanding the overall research work. So that third-party content that is part of the work falls within this definition of a research work. And this actually is a pretty broad definition. We intentionally made it sort of as we looked at the various samples that were out there that were existing, and then we decided we wanted to make this sort of as broad as possible, to make it as all-encompassing as possible. And so you've seen those bullet points. Again, it's supported, indirectly by public funds, so research salaries, and also taking this approach ensures that it's not sort of limited to the sciences where you typically have grants, but it would also include social sciences, history, law, where you have people getting salaries, but they typically don't get grants, or not, it's not nearly as grant heavy as it is in the hard sciences. And again, the goal is to advance the idea of the public policy goals of secondary publication rights, the widespread dissemination of research results that ultimately are being paid for by the public. Now again, even though we came up with a pretty broad definition, an individual country is certainly able to come up with a broader definition, meaning they could basically say that it applies even if it's entirely privately funded, that somehow it is, by having this public nexus, public funding nexus, there's this underlying assumption that SPR is flows from the fact that the public is paying for it, and since the public is paying for it, they should have access to it, to the results. So that's sort of the underlying premise. But a government could certainly decide, no, that's not the premise. The premise is that it's more of an author's right concept, meaning that regardless of how the author is being, whether or not they get a grant, or if they get a grant from a private source, that somehow they should, nonetheless, regardless of the source of the funding, they should have the right to make it widely available. So again, you could say more of an author's rights theory than a sort of a public funding theory. But again, that's not the approach we took. We basically said, look, as long as there's public money that went into this, then the author should have the ability to make sure that the public gets access to it. So next slide, please. So then we also defined version, and some of the others, and basically we again took a very broad definition of version. So it's basically the version of the research work. And the thinking there is that some of the other statutes, limited to sort of, a preliminary draft, or, a draft that's not yet been peer reviewed, or it's been peer reviewed and accepted for publication, but not yet published, not yet actually edited or typeset. And we didn't want to sort of limit it to a specific version. Our view is that it should be any version, and it's sort of like the author can decide which version they want to make sure is publicly disseminated, especially because, as you know, some publishers are pretty slow. And so the time between when you have actually written the article and it's pretty much done in your mind as the author, from the author's point of view, until the time it actually comes out, might be a year, might be 2 years. And so, we wanted to make sure that people aren't limited in which version, or that they could put out initially the initial version, a preliminary draft, and then they can keep on putting newer drafts out until it's actually published, and then put the final version, make that available. That again, giving the author the broadest flexibility in how their work is disseminated. Next slide, please. And then we also define what the term freely available means, because the idea is that as you'll see in a minute, that a research work in whatever version will be freely available, that the author has the right to do that. And so freely available means immediate and permanent access, free of charge for anyone to use, download, distribute, adapt, or build upon, so that it could be somewhere, presumably online, where where the public can access it for free. They can download it, they can distribute it, basically that the again, the author has the right to make it available in this for all of these uses in the broadest possible way. And again, this was actually language that we took from Creative Commons licenses. Next, please. So then we take all of those definitions and put it together in this Article 1. So the author of a research work, and an author we don't define here because, again, this is part of the EIFL model law, and author is defined somewhere else. And so all the issues about who is an author are taken care of elsewhere in the statute, so we didn't feel we needed to address that here. The author of a research work, so you see that term shall have the right to make that work and any of its versions, so you see versions, and then freely available to the public in an online repository immediately after its acceptance for publication by a publisher. So that is the operative provision. And so to some extent, it's again to the point here is to allow the author to continue to have this right, even if the publisher contract says is contrary to that, says they can't do it. The idea is that the author still has the right to make it available. And we have language later on that makes that even less, eliminates any ambiguity about that, but that's sort of the purpose here. There's no embargo period, so again, he can, the author can have it in the online repository immediately after acceptance. It doesn't need to, you don't have a 6-month embargo or a 12-month embargo. Again, it applies to all types of research because how the term research work has been applied, and it applies to all types of publicly funded research. So again, there's because of how we defined research work, you don't have any kinds of limitations on, does it need to be, 100% publicly funded, and what happens if it's commercial and non-commercial? That's still part of the falls within the definition of research work. And again, all versions, even the version of record, which is important for citation purposes, or an earlier version. This draft law applies to all of those. Next slide, please. Now, and this is where it gets a little funny. I mean, so we're giving the author this right, but how do we know that the author will exercise his right? And so that's still perhaps up to the funders or the employers of the author to make sure that the author actually exercises their right. But that's sort of outside of this provision, and that's sort of between the funders and the author, or the institution and the author. But to some extent, that is still a critical piece because we just know from experience that even if you give the author the SPR for a variety of feature reasons, and most likely at that point it's just sort of laziness. Or even if they're not being prevented by the publisher, they're just not going to make it available. But here, if you had this provision, they would have the right, the publisher couldn't stop them, but they still might not get around to doing it because they're on to the next article, and they've lost interest in this article. And so it's like, how do we make sure that it does end up in the repository? But that's an issue again between the funder and the author, that it has to sort of be up to them, the funder, to make sure that the author actually gets the work into the repository. Next slide, please. Now, what we've found is that in some instances, publishers have retracted acceptance once they found out that an author made the work available in a repository. And so this is the provision is to make clear that the publisher can't retract acceptance after the author has gone ahead and made the work available in a repository. That it's sort of that there would be an understanding or an expectation that the author, the publisher knows that this is always a possibility and hopefully even a likelihood, and this will all be part of the environment. But this is to make sure that the publisher can't retract the work after the author has made it available. Next slide, please. Now this provision is less a part of what is the bundle of rights of the author, and this is more the bundle of rights of the online repository. So the online repo we want to make sure that the versions of the works are as give all the information. So that they explain who the author, that the online version, it explains who the author is, who the funder was, who the publisher is, and also importantly, an indication of which version, is this pre-publication? Is it post-publication? Is it preliminary? Is it peer-reviewed? That so that the reader knows which version they're looking at. But uh, and again, hopefully the author, when they make their work available to the repository, will provide all that information. But again, from experience, we know that again sometimes the scholars have kind of moved on to other things, and they can't be bothered to give that kind of information. So it might have to be the operator of the repository who adds that. But we want to make sure that there's nothing that would suggest that the operator of the repository can't add that information or associate that information with the version of the research work that has been made available. And we also wanted to make it clear that somehow the author didn't lose his SPR, his secondary publication right, if he didn't provide all this information. I mean, again, our goal is to make this as easy as possible and make the works as broadly available as possible. So again, this is not seen as an obligation of the author to provide this information, but that the operator of the repository has the ability to add this information if it's missing. Next slide, please. And again, this again is to just make sure that that there's no ambiguity, that any contractual provision which prevents what's provided for in the operative paragraphs of 1 and 2 shall be null and void, to make it clear that the publisher can't take an author's secondary publication right away from him or her. Next slide, please. So again, we've seen that, and then just to remind you, Article 8.5 has the definitions that we saw earlier. And so these are just some examples. You can, a researcher is able to, take a publicly funded peer-reviewed work and make it openly available in an institutional repository, even if the publisher hasn't agreed to it. An institution can build an online repository showcasing the research outputs of their researchers, and especially they can do this without the author's permission if they own the secondary publication rights. So, for example, if the employment rights with the scholars or the researchers gives the institution those rights. And by virtue of the fact that that they would then be considered, the institution under those circumstances could be considered the as the employer, they could be considered the owner of the copyright. And again, this is when you structure this as a copyright, then who the author is. It could be if it's basically a work made for hire at that point, then the institution is the author, not the individual who actually did the work. And then the open access mandates setting set by funding institutions will be implemented. I mean, so this would sort of make sure that that if the open access, if the funding required the author to do this, to make it available through a repository, that then the publisher can't say no, you can't do that, because again we have that contract override provision. Next slide, please. So again, these are the names of the people who were part of the working group, and I just want to thank EIFL for sort of organizing this project. I found it very interesting, and I hope that other countries, sort of look to this model law as they are considering SPR, and base their laws on our thinking. So we're over to you, Teresa. Thank you very much.
Yeah, thank you very much, Jonathan. And as the slide is showing there, and the updated version of the model law, including the SPR provision, is available online on the EIFL website, and so you can check it out and download it now. If you go to the website and then go to resources, it's the first option. I think Iryna has also put a link directly to the resource into the chat. So let's what I'll do now is I will comment very briefly on 4 issues that were debated by the working group, and some of which have been mentioned by Jonathan. But first, I want to say that the provision does meet the 5 policy options in the European Commission's study that was released in 2024 on improving access to and reuse of research results, publications, and data for scientific purposes. Now, and I'm just going to show you a slide if I can get it back up on my screen. So if you just bear with me for 1 second, I think I need to reopen it. And policy options slide. Now let me see if I share this. Will you be able to see it? Yes, now it's there. Okay. All right. Are you seeing that slide? Yes.
Yes.
Yeah. Okay. Great. So the EIFL provision meets these 5. So in the study there are policy options on different aspects. But specifically on secondary publication rights, there are 5 policy options recommended by the authors of the report. So including, the first one is to include a broad range of scientific output. So not only journal articles, which is what we can see in some of the laws that have been enacted. Well, the EIFL provision enables all types of outputs: articles, book chapters, images, and tables. It also recommends to relax the threshold for public funding to 50% or less. Well, in the EIFL provision, there's no minimum funding requirement, and it includes direct and indirect public funding, as Jonathan described. It also recommended to expand the scope of the versions to include the version of record, which the authors said is essential for citation purposes. And we have included all versions, including version of record, and to minimize. Sorry, I'm minimizing my screen. And to minimize embargo periods, so there should be no embargo or only a short embargo period. And the EIFL provision, there is no embargo. And then it should allow all types of uses. So the restriction to specific forms of use, such as non-commercial purposes, seems outdated and overly restrictive, according to the authors of the study. So we paid attention to that, and we've made sure to enable all types of research. There is no distinction between commercial and non-commercial research. So So on some of the issues that we discussed, first of all, was like what type of a right is the secondary publication right? Or as Martin Zentleben would say, how do we conceptualize secondary publication right? So it's not an exclusive right in the traditional copyright sense. So it's not an economic right, and it's not really a moral right. So it's a right empowering authors, a new type of right, like a public right. So that's for that reason in the EIFL draft law, SPR stands by itself in a new Article 8. So it's not under the category of economic or moral rights. Second issue we debated at some length was, is SPR a right or an obligation? So is SPR a right that the author can freely exercise or not, or is there an obligation on the author to exercise the right? Well, as Jonathan mentioned, the EIFL provision creates a right to republish the work, but it doesn't create an obligation. So, of course, the objective of SPR is to increase availability of research outputs. So, of course, if researchers don't exercise their right, then that's a problem. So there should be a mechanism for funders and institutions to step in, and many already do so through funding agreements and employer contracts. And in terms of copyright, so SPR is an unwaivable right that belongs to the author or the employer or the funder as part of their bundle of rights. So enforcing SPR is like a public access mandate, we felt, which is conceptually a different thing from a copyright or a related right under copyright law. And Bulgaria is one country that has implemented both a secondary publication right and a secondary publication obligation. What's important to note is that in Bulgaria, SPR, the secondary publication right, is in the copyright law, but the secondary publication obligation is in the law on research. So we would kind of follow that approach, that we would think the obligation is appropriate to be somewhere outside the copyright law. The other issue that we looked at was citation information, and as Jonathan mentioned, the inclusion of citation information is not made mandatory. Now, again, this might seem a little bit counterintuitive, but what we thought was important to untie the mandatory inclusion of citation information in a repository from the secondary publication right. The rationale was to remove the risks of publishers using a formality, the mandatory inclusion of citation information, to argue that the SPR has not been properly exercised and that may trigger a takedown demand or an infringement action. But at the same time, it creates a mechanism for citation information to be added. And the other consideration that we had was that, since SPR aims to encourage researchers to provide public access to their works, the fewer obligations that we impose on the researchers, the better. And then finally, on the funding requirements, we were very keen to ensure that all types of publicly funded research are covered, not only as a matter of law, but also as a practical matter. And so for that reason, we had this wide definition to include the disciplines that are not typically funded through direct research grants, but are nonetheless paid for through not insubstantial amounts of public funds. And it would apply to public-private partnerships as long as there is some public funding. And as I said at the beginning, the EIFL draft law, the provisions in the law are a work in progress, and the provisions for sure will be reviewed and updated from time to time. So we are now just coming up to the end here, and I see that we've got one question in the Q&A, and then I also have a brief question for both of you as well, Jonathan and Iryna. So shall we start? I'll tell you what we'll do. We'll start with a brief question to Iryna, and then I'll have a question for Jonathan, who can also perhaps take the question from in the Q&A. So Iryna, my question to you is that, as we have heard so far, is that SPR is implemented in European Union member states. So why is SPR also important for researchers outside of the EU, like in neighboring countries in Europe and in Africa and other regions? Or how is it important for researchers in other regions of the world, not only in the European Union?
Well, Teresa, it's really important because a lot of research in those countries is funded by international funders who already have open access requirements to deposit in repositories. And sometimes it's a little bit difficult for researchers to exercise that requirement because they are afraid of publishers' non-repository friendly policies. Also, institutions in those countries have either policies or requirements or recommendations to provide open access. So SPR would make it easier to comply with those recommendations. And simply, if researchers believe that open access is a good cause, then they can exercise it easier. And I'm from Ukraine, and SPR has been included in the draft act suggesting some revisions to Ukrainian Copyright Act, and there was a period of public consultations, and some of the feedback that we received was a little bit similar to the questions that Jonathan is about to answer. Why exceptions and limitations are not enough? Why do you really need SPR as a right? And I'll hand it over to you, Teresa, and to Jonathan.
Okay, thanks, Iryna. So, Jonathan, I had a sort of a similar question in the sense to Iryna, to say that, you know, a question about implementation. So, since this provision is a standalone, self-contained provision with definitions, I mean, do you agree, or do you see that it could be easily slotted into the national copyright laws of different countries? And is it something that might be under consideration in the US?
So the first part, yes, it should be able to fit in anywhere. I mean, the only term that is not sort of included is author, and so that would be sort of how it's defined elsewhere in the statute, and but typically it is a defined term, or if it isn't, then the country has never seen a need to it. But again, you would just have to issue, maybe make it clear, is it, or the country would have to decide, does it include employers of researchers, or is this the researchers themselves? They would just have to sort of sort that out. We decided we didn't need to decide that because it's a copyright law, and let the copyright law decide it. But if it's going into the copyright law of a country that doesn't have that defined, then they would have to sort of decide the scope. I mean, who is included? But we thought we didn't need to decide that, whether it includes the employer, who has the right, the employer or the employee. That would be a matter for the copyright law to decide. In terms of whether the United States is looking at it, there really hasn't been any discussion here about that. I mean, the whole idea of contract override, there's a lot of resistance to here, whereas in Europe it has been much more seen as much more acceptable, that you're sort of putting restrictions on the publisher, that the author has rights that sort of survive conditions placed by the author, whether it's with respect to exceptions or other things. That's just again, that's been broadly accepted in Europe, and but not here. And so I mean, we've been trying to get this, things, trying to get other ways of encouraging open access adoption. And so So we do have open access policies in the federal government, which basically say if you're accepting funding, then you need to make your material available. But there's been embargo periods, but then there's a new memo, but then there's a new administration. So, it's kind of messy. But the short answer is no. We haven't done that, but it's all because we just have this we just haven't been as accepting of the notion of limiting the rights of publishers once, they say, oh, it's a contract, you signed away your rights, too bad. And in Europe, they're more willing to say, no, we want to make sure that these rights are unwaivable.
Okay, thanks, Jonathan. So now I'd like to ask you if you could take a question that we've had in the Q&A, which is this issue of how do we conceptualize SPR? If it's not an economic or moral right, what is it? What is the argument for SPR not to qualify as an exception? And how do you reconcile SPR with academic freedom? And I'm going to put into the chat a link to a document from a number of European academics where they actually look at they address these issues in detail, like what type of a right is it, and how does it work? So that also might be useful for answering the question. Jonathan, have you anything to comment on that?
Yeah, well, I guess I'll do it backwards. First of all, it's easy to reconcile with the academic freedom of the author because it's, as I said, and as Teresa said, it's not an obligation on the author, right? They don't have to make it available in a repository. It's just ensuring that they have the right to make it available in a repository. The obligation would only come on the funding side, right? That's how, we're not doing that. That's like someone else, again, like I said, in the United States, that's a federal government policy, and the EU has policies, and certainly funders have policies. Individual, funders that are not government funders have open access policies. So that's the any limitation on the academic freedom is not coming from this provision. It's sort of tied to the funding. Again, one can imagine one making it more adopting a policy saying, no, it's got to be open. That would be a different issue, but we're not saying that, precisely for that reason. With respect to, which is it? Is it to some extent it's neither, and to some extent it's both. It's both an economic right and it's a moral right, because it's typically the economic rights are the rights of the author against the world, and a lot of the moral rights, as a practical matter, are the rights of the author against the distributor, the publisher, saying, okay, you're publishing my work, but you always have to give me attribution, or you're publishing my work, but you can't change things, and those are unwaivable. And so here to some extent, it's in that respect, it's sort of, depending on which way you're looking at it, it's more of a moral right or more of an economic right. And so I guess my personal view is I actually thought more of a moral right. So when we were working on this, I actually first put it in as a moral right. And then the other people on the committee say, whoa, no, it's not a moral right. It's more of an economic right. So we decided, okay, it's neither this nor that. It's sui generis.
That's right. It's his own sui generis right. So Iryna, there's a question from Robert in Uganda. So perhaps I'll ask you to take this one. How can we support this agenda in our small ways? I see it requires the Parliament to enact the law, but what can we do in small ways that may be at institutional level? Because I know you do quite a lot of work with institutions in Uganda.
Thanks a lot, Robert, for your question. We've been working with Uganda National Council for Science and Technology on their open science policy, which they're about to release in the coming days, basically. And it's one of the best open science policies in the world, and it creates this obligation to provide open access. And when there was a consultation on the policy, there was a decision that a collective action is needed on the national level. So it's not enough for the Uganda National Council for Science and Technology to have this open science policy. It's also important for universities to act accordingly, and other national steps are needed. So I'll include you, Robert, in the discussions and next steps planning. And thanks again for your interest.
Okay, so thank you very much. So I think that's, I don't see any more questions in the Q&A, and we are coming up to the hour, so we've actually gone a little bit over our time. So with that, I would suggest that we wrap up this session, and I thank everybody for coming to the session, and we will be sending out a recording and links to the slides. And once again, thank you to the working group who worked on this, and we hope that it'll be useful and to everybody in raising awareness and helping to implement the open access public mandates.
Thanks a lot, Teresa, for
So
driving this
thanks very
work.
much to everyone. Thank you.